Hello everyone. Welcome back. Today we are looking at one of the biggest problems the Trump administration is facing: the use of nationwide injunctions by local district courts to derail President Donald Trump's agenda. Specifically, we are talking about judicial overreach, unelected judges stepping way beyond their constitutional lane to block the executive branch's lawful authority. And at the center of this storm is one name that keeps popping up: Judge James Boasberg. We'll unpack his rulings, his potential conflict of interest, and why this whole trend smells like a power grab by the judiciary. Let's start with the big picture. Nationwide injunctions. What are they? Simply put, they're when a single district court judge, often sitting in some liberal enclave like DC or San Francisco, issues a ruling that doesn't just apply to the case in front of them, but halts a policy across the entire country. Think about that. One judge, not elected by anyone, can hit the brakes on an agenda voted for by millions of Americans. Since Trump took office in January 2025, we've seen dozens of these injunctions, over 40 by some counts, targeting everything from his deportation plans to federal workforce reforms. It's not just a legal tactic, it's a weapon to kneecap the executive branch. Now, the Constitution is clear. The executive branch, led by the president, has broad authority over national security, immigration, and enforcing the law. Article 2 doesn't say, oh, but check with Judge so-and-so first. Yet here we are, with district courts acting like they're co-presidents. This isn't just judicial review, it's judicial rule. And the poster child for this overreach? U.S. District Court James Jeb Boasberg, Chief Judge of the D.C. Federal Court. Let's talk about Boasberg. He's an Obama appointee, confirmed in 2011, and he's been a thorn in Trump's side since day one of his second term. His big moment came in March 2025 when he issued a temporary restraining order blocking Trump's use of the Alien Enemies Act, the AEA, of 1798 to deport alleged members of the Venezuelan gang Tren de Aragua. Trump signed a proclamation invoking the AEA to fast-track these deportations. No hearings, no red tape, just get these guys out. Now here's the key. Despite the leftist propaganda, the AEA isn't just a wartime authority. The text says the president can act during a declared war or any invasion or predatory incursion by foreign nationals. That "or" is huge. It means war isn't required. Trump pointed to TDA's violent crime wave, murders, drug trafficking, as a predatory incursion threatening public safety. It's right there in the statute, a flexible tool for national security, not some dusty relic tied to muskets and cannonballs. Boasberg didn't see it that way. On March 15th, he slapped down a nationwide injunction halting all deportations under the AEA. He ordered planes already in the air to turn back, planes carrying over 200 alleged gang members to El Salvador. His reasoning? He said the deportees deserved a chance to challenge whether they were really gang members, calling Trump's move awfully frightening and a stretch of the law. He even accused the administration of rushing the flights to dodge his ruling. The D.C. Circuit upheld him 2-1, and now it's headed to the Supreme Court. But here's the problem. Boasberg had no business stepping in. The Supreme Court already ruled on this back in the 1948 case of Ludek versus Watkins. That case dealt with a German national deported under the AEA after World War II. The court said loud and clear that the president's use of the act is a political decision, not subject to judicial review unless it's a narrow habeas corpus claim, meaning you can only challenge your detention, not the policy itself. The justices gave the executive branch wide latitude, saying it's tied to national security judgments that courts aren't equipped to second guess. Boasberg's acting like the predatory incursion clause doesn't exist. He's rewriting the law to fit his view, ignoring that "or" and the 1948 precedent. His due process argument? It's a modern gloss that doesn't hold up against the statute's plain text or Supreme Court history. Now let's get to the juicy part, Boasberg himself. Who is this guy and why does he keep landing Trump cases? He's not just any judge. He's the chief judge in D.C., a court stacked with 11 out of 15 active judges who were appointed by Democrats. That's already a red flag, but dig deeper and it gets murkier. Posts on X have pointed to a potential conflict of interest involving his family. His daughter, Judge Boasberg, works with an NGO called Partners for Justice, which provides legal aid to, among others, undocumented immigrants and criminal defendants. Some claim, without hard proof, that her group benefits from lax immigration enforcement, maybe even getting government funding that Trump's policies threaten to cut. If true, that's a motive. Dad's rulings could protect Junior's paycheck. Is it a smoking gun? Not yet. There's no public evidence of direct financial ties or specific grants tied to Trump's agenda, but the optics are terrible. And then there's the case assignment issue. Boasberg's presided over multiple high-profile Trump cases, the AEA fight, grand jury disputes from the 2020 election probe, even a signal messaging lawsuit tied to the Yemen strike. He says it's random, assigned by a computer system, but let's do the math. The D.C. court has 15 active judges. The odds of one judge getting this many Trump-related cases by chance? Slim. Somewhere at around 1 in 100 or less, depending on the caseload. It's not a conspiracy theory to ask, is someone steering these to him? The judiciary won't say, and that silence fuels the suspicion. And the family ties don't stop with Boasberg's daughter. Boasberg's wife, Elizabeth Manson, is a big player in her own right. She's the president of Verate Incorporated, a nonprofit that's all about labor rights and supply chain transparency. Sounds noble, right? But here's where it gets sticky. Verate's raked in over $29 million in federal contracts, a chunk of it from U.S. aid. That's taxpayer money, folks, flowing to an outfit that critics say benefits from keeping undocumented workers in the mix. Posts on X and some outlets like SimonRasica.com have pointed fingers, claiming Verate's work focused on exploited labor, often migrants, could thrive under lax immigration and enforcement, the exact opposite of Trump's deportation push. Now let's be fair. There's no public paper trail showing Verate directly profited from Boasberg's AEA ruling or that Manson lobbied him to block those deportations. Her group's mission is global. Think sweatshops in Asia, not just U.S. border policy. But the optics? Awful. If Trump's agenda cuts U.S. aid funding or dries up the flow of undocumented workers Verate claims to protect, that's a hit to her bottom line. And get this, Manson's also dropped over $10,000 on Democratic campaigns, including thousands to Hillary Clinton. So we've got a judge married to a well-connected activist with a financial stake in the system, ruling against a Republican president she's openly opposed. Coincidence? Maybe. But it's just hard to swallow when Boasberg's the one deciding if gang members stay or go. This isn't just about money. It's about power. If his wife's tied to the same liberal networks that cheer every time Trump's agenda stalls, how impartial can Boasberg really be? Judicial ethics say he should recuse himself if there is even a whiff of bias. Yet here he is, front and center, issuing nationwide injunctions like he's got no skin in the game. Add that to his daughter's gig, and maybe you've got a family portrait that screams conflict of interest. The Trump team's noticed. Caroline Leavitt called him out from the White House podium, tying Manson's donations to his rulings. No hard proof of a quid pro quo, sure, but the stench is there. And it's one more reason to question why this guy keeps getting Trump's cases. Boasberg's not alone either. Other judges are in on this game. Take Judge Theodore Chuang in Maryland. He blocked Trump's attempt to dismantle U.S. aid, calling it unconstitutional. Or Judge Reyes, who mocked Trump's military readiness order in open court. These are district judges, low-level, local players issuing rulings that grind the whole country to a halt. The Supreme Court warned against this in Trump versus Hawaii in 2018, saying lower courts can't micromanage national security. Yet they keep doing it. And Boasberg's AEA ruling is Exhibit A, ignoring the law's clear or and predatory incursion language to impose his own agenda. But here's the kicker. The executive branch does not have to sit there and take it. Andrew Jackson famously ignored a Supreme Court ruling in 1832 saying, "John Marshall has made his decision, now let him enforce it." Trump's team has hinted at defiance, arguing Boasberg's order was moot once planes left U.S. airspace. They're not wrong to push back. Courts don't have armies. Their power relies on the executive's willingness to comply. If a judge overreaches into Article 2 territory, like immigration enforcement tied to a predatory incursion, the president can say no thanks and let the chips fall. That's not lawlessness. It's the Constitution working as intended, balancing power between the branches. So why does this matter? Because if the district courts can keep pulling this stunt, Trump's agenda, your agenda if you voted for him, is dead in the water. Deportations stalled. Federal reform blocked. National security at the mercy of some judge's feelings? This isn't about legality, it's about politics. Boasberg and his ilk are flexing power they don't have, betting on a liberal bench to back them up until the Supreme Court steps in. And with a conservative majority up there, they might not win. The AEA fight's headed to the justices now, and if they stick to Ledecky and respect that or in the statute, Boasberg's toast. But the damage is done. Months of delay, millions of dollars in legal battles, and a signal to every activist judge. Go ahead, swing big. Now, Congress could fix this, limit nationwide injunctions, as Senator Chuck Grassley's hinted at, but don't hold your breath. Until then, it's Trump versus the robes, and the stakes are the rule of law itself. Well, that's my take, folks. Now, I'm not a lawyer, but the facts do seem clear. Local district courts should have zero authority over the executive branch except in very narrow rulings that apply only to the specific litigant, not nationwide injunctions. Let me know what you think in the comments. If you find value in my content, please like, share, and click that follow button. If you'd like to support my mission, please join our Facebook subscriber group. Going forward, subscribers will get a first look at new podcast episodes with a week or two delay before I release the whole episode to the public page. Thank you all for watching. We'll see you in the next one.